The problem with us practitioners in the criminal courts that we spend an enormous amount of time on the merits of the case, where we decide whether a person is guilty or not. What is foremost in the mind of the offender, if we accept the people that appear as guilty, is what sentence am I going to get? That's the first thing. Secondly, what benefit does it have to the community? We as judicial officers, we have an obligation to serve our community. Let's rather deal with that and find other ways of dealing with the backlogs instead of pushing matters through hastily but not looking at the root of the problem. What we do is we deal with the merits. That officially closes off the first phase of the case. And it has become the norm that we have very little information about an offender. Similarly, we have very little information about the victims. And we focus on the crime that was committed. And it's right in our law that we equally have to apply our sentence to both society, the offender, and the victim. So on that score alone, we are obliged to look at it. But you cannot give a just sentence, and that's the test, whether the sentence is a just sentence, if you do not know enough of each one of those components. I want to relate it to a tradesman who has a big toolbox, but he prefers the one chisel and the hammer. That's what we do. The law provides us with a range of tools that we can construct sentences. Just as an example, you have something like correctional supervision, which is non-custodial in its nature, where you have a free hand. You've got a wide discretion as to what you can build into it. We have deferred sentences, which I don't even see anymore. It's been on the statute books for 50, 60 years, maybe longer. But first of all, we are not aware what's in our toolbox. Hence, we don't know what we can achieve with it. And I think we should be, and I've dealt with the education issue, but we should be constantly reminded of what we can use in terms of the law and still eventually obtain a just result. I've spoken about the fact that we have all these tools to our disposal that we can sculpture with a sentence. But what we must realize as judicial officers is that you can have a combination of many of types of sentences, but it should be structured to suit that individual's needs. And we must steer away from, and I'm very tempted to say that we must steer away from pro formas where we tick boxes, because that tend to lead to just ticking the boxes without applying your mind. But we have to apply our mind. What does this person need in order to serve the purpose of sentence, whether it's retribution, rehabilitation, victim empowerment, or any of the other objectives of the sentence. But also when it comes to non-compliance, you know exactly which one of those you have to address. And it's not because I feel so, it is the law. There are reported cases that says we must do that. But we often forget about those.